All right. All right, ladies and gentlemen, we're going to call this meeting of the Juvenile Justice Committee to order. And do we have a sign-up sheet out there? All right, we have several bills on the agenda today, including, let's see if I can get there. House Bill 21 by Mary Margaret Oliver. Let me see. Which is the adoption and post-adoption contract agreements bill. We have House Bill 446 by Representative Peake, who's presently involved in another committee meeting, so we're going to try to give him a little time. And then we also have House Bill 369, which is Representative Fleming's bill regarding termination of parental rights under circumstances in juvenile and superior court. What I'll do is, if Representative Oliver, if you wouldn't mind presenting your bill first, that'd be all right. Which, 2, 3.
Ladies and gentlemen, thank you, Mr. Speaker, Mr. Chairman. And forgive me for having my back to several people. Thank you very much for all the time that's been invested in crafting improvements and amendments and redrafts of House Bill 21. I offer for the committee's consideration this afternoon LC 295549, which represents a good number of amendments and corrections and improvements.
If I could, is that LC 295549S?
Yes, sir.
The substitute? Okay.
Thank you. I'm working from LC 295549S. Thank you. This incorporates a number of amendments and improvements that come from the very detailed and helpful discussion that we had previously from the subcommittee and the full committee. And with the chair's permission, I will list for you the amendments that we made, and particularly ask Subcommittee Chairman Welch to chime in or correct me when I've stated something incorrectly. We, based on discussions, made some changes from the bill that came out of subcommittee last week by adding the limitation related by blood or marriage on line 14 and related by adoption in 15. Again, these are for the purposes of setting forth a voluntary opportunity for adopting couples and birth families to make an agreement based on a post-adoption relationship as they determine best that is voluntarily entered into. We also corrected that only a child 14 years or older shall be a party to this post-adoption agreement to reflect the consistency in Georgia law that children 14 and older have certain preferences of decision making. We clarified on line 24 that the information that parties may choose to share may be about the child. In other words, that really reflects what is the primary request of many families, which is to share medical information. That's been very consistent. You know, before there was the adoption registry, there was always a statutory opportunity for an adoptee to go to court to open an adoption record. And there was somebody did a lot of work to do a survey that 110 out of 112 petitions to open an adoption petition record was for the purpose of getting medical information. So we wanted to clarify that medical information was part of information that may be exchanged in a post-adoption visitation. On line 32 to line 33, we have specifically granted to the parties an opportunity to waive enforcement They are not required in the agreement that they may enter into to have that agreement enforced. They may choose to write as a letter of intent and waive enforcement through the court. On line 46, we have again limited the parties to mean a child over 14 years old. On line 55 through 57, we again give the opportunity to the parties to decide whether or not they wish to file to enforce or terminate an agreement. And we have limited in line 62, this correction came from Chairman of the committee, that with respect to post-adoption agreements that provide for court modification, if parties wish to have that enforcement, only the adopting parent may file a motion seeking, not the child or not the birth parent. I believe 68 to line 70 was in the version that passed out of the committee, which allows the people to engage in mediation. And in beginning paragraph H on line 71, we provided for cost of litigation to be borne by the party bringing the action. That's a brief summary. I'm aware that Subcommittee Chairman Welsh wants to make a good amendment, one further small good amendment that I think is appropriate, and I'm happy to answer questions, Mr. Chairman, if that's appropriate.
Thank you, ma'am. Is there any questions from the committee? Okay, do we have anybody to speak to the bill? Okay. Yes, sir.
You and the members of the committee allowing me to ask a few questions about the bill. I will tell you that I've heard a lot about the bill. I have not had an opportunity to fully answer the questions I'm going to ask you today in my own mind, but I would want them to present them to you. The goal I would have through adoption, which is very important to me, is that we encourage it as much as possible in the state. And I know that Representative Oliver has the same goal. We both are big supporters of the adoption process. I'm particularly a supporter because I think there's nothing you can do more important than to give a child a home. I'm also a big supporter of adoption because I think it's a great alternative to something that I try to avoid, and that is abortion. The intent, though, after that I want to make sure that we're not doing with this bill is to do something that I think, I'm concerned, could harm adoption. And that is, I just want the committee to make sure that we're doing nothing that is going to delineate or treat different adoptive parents from parents who have a child that's natural born to them. And what I mean by that is this. When a child is adopted or adoption is considered, the birth parents can say to the potential adoptive parents, I want you to sign a contract that says I can have a relationship with these children going forward. And if at any time in the future, somebody other than, if we have a dispute about whether or not I need to continue to be involved in that child's life, somebody other than you, the adoptive parent, I want to be in the decision-making mode as to whether or not I need to continue to be involved in that child's life. In other words, think of it this way. Anybody on this committee that has a child, is there any kind of contract you could enter into when that child is born to say that somebody else will have the ability to say when they wanted to see that child, your child, other than you, the parent? I just want to make sure that we protect the ability of the adoptive parent 15 years down the road, that when they think, and only they think, that my child does no longer need to have any interaction for whatever reason with the biological father or mother, that be where it ends. I don't want us to introduce inadvertently into the situation where someone, because they can, says, I still want to be interacting with the child, and the adoptive parent says, you know what, it's not in the best interest of my child. That's my concern. I will say to you, I do not have an answer to the question of whether or not this bill does that. But I know that the committee has studied. I know that the author is well intended. I know the chairman and others on the committee have thought through these possibilities, and that's the only thing that I would ask of you. Let's make sure that we don't treat the adoptive parent any different than we do the parents of a natural-born child, because I just want to make sure that we don't treat the two at all any differently. Thank you, Mr. Chairman.
Thank you, Mr. Fleming. Let me, if I could, try to address some of those issues
Yes,
you
sir.
have voiced right there. I share your concerns about that, and I think many, if not all, folks on this committee share that same concern. A child being born into a family is different from a child being adopted. Now, from the time of adoption or the time that child becomes a member of that family, I agree with you, and I believe almost everybody here, if not everybody here, would agree with you that there cannot be a distinction between the manner in which the law treats that parent with respect to control over that child and the ability to parent that child. You hit the issue squarely. That was of great concern to everyone involved in crafting this bill. And what we came up with was that we had to have a bill that said, okay, it's all right to have these agreements. And what we did is we put a provision in there that says the parties can agree to have, just like they do now, they can have a non-enforceable agreement that all they have to do is just put a provision in the written agreement that says it's not enforceable in court. They also have a provision in here in lines 61 and 62 that says, with respect to post-adoption contract agreements that provide for court modification or are silent to modification, only the adopting parent or parents may file a petition seeking modification. And you know, I think the motivations that you have for keeping adoptive parents treated exactly like birth parents, which I think everybody would agree is the best interest of the child or children that are going to be citizens of the state of Georgia, and for all citizens of the state of Georgia. And that what we're trying to do is provide a method for the biological parents to have another alternative to abortion or placing that child in harm's way. And I think we've tried to address it. And I feel confident that we've taken steps in the right direction. I appreciate your comments, and I don't think Representative Oliver would be averse to improvement on the bill, improvements and improvements. So I think we have tried to do that, and if we've distinguished between the treatment of birth parents and adoptive parents, it's been unintentional.
If I could ask one question, Mr. Chairman.
Sure.
Is there any way under this bill that I, as an adoptive parent, could enter into a contract with someone else, the biological parent, let's say, that I could not unilaterally end the relationship or the ability for that biological parent to see my child when that child was 10 years old for whatever reason I felt? Are we setting up the possibility for that to occur?
That is something that could happen. That is something, but the reason for that is because in a biological situation, it's the difference between an adoptive and a biological situation is, in a biological situation, the biological parents are the legal parents moving forward.
Correct.
The adoptive parents don't have to engage in that, and we provide that they not only do they not have to engage in that, but they also have a provision that say it's not enforceable in court.
But if the biological parent said we're not going to let you adopt unless you sign this, they would have to if they want to adopt the child, correct?
you know, if they choose to go that route, they could. But then, you know, there's also the termination of rights issue that could happen, and that wouldn't, if there was a termination of rights and it's adopted out of, if the child's adopted out of a situation where the parental rights are terminated, they wouldn't have this any kind of agreement that they'd have to look at.
And Mr. Chairman, I appreciate you letting me speak, and I don't want to belabor any further the point that I was trying to make, and I completely understand that the Representative Oliver is trying to do something very good, particularly in the area of foster adoptions. And I don't know if the committee can do this, or it may not. Sometimes things that you want to do are not possible due under the law. But if it's possible to separate foster adoptions from all the rest of adoptions because we have a problem with them, I wonder if that narrow remedy would be better so that you don't even come close to the problem that I was bringing up. But I'll leave that with the committee to decide.
Well, maybe I'm missing part of the issue. If I'm missing part of the issue, you know, I don't see how we could do more than what we're doing now. If we can, we want to do it.
And I don't have the answer to your question, Mr. Chairman. And unfortunately, not having served on the committee and heard the testimony, I'm sure subcommittee probably looked at this too.
Sure.
I'll try to educate myself better, but I did want to express those concerns at this point. And
Okay.
I appreciate you letting me do it.
If you may have some questions from the committee.
Sure.
Mr. Welch? Oh, Ms. Oliver?
There's one statutory reality in our code now where a parent is asked to relinquish authority for visitation to a third party, and that's to grandparents. And I will tell you that some of the case law that comes out of these difficult areas relates to grandparent issues where birth parent are deceased, and that reflects a lot of the dysfunction that may occur for foster care children. Foster care are legal orphans in some cases, a number of cases. But the reality of all of the adoption agencies who wish to have this opportunity, and that's most of them, have determined that they can't really tell their adopting parents and birth parents that these agreements are lawful because the Georgia law is silent. So in court, including the private adoption or the independent adoptions, is for their benefit also, where they wish to do it and where they think it's in the best interest.
Representative Oliver, and I appreciate the point you're trying to make, but I bet in your analogy with grandparents' rights, there is no distinction made between grandparents of adopted children and those of biological children. The other thing I would say to you is I have no problem whatsoever with the committee allowing these contracts to exist when the adoption occurs. I would just like Georgia law to say that the parents can solely and unilaterally terminate the ability, no matter what this contract says, at a time they deem necessary, whenever that may be, that it's no longer in the best interest of their child to see whatever person this contract may have said could see them.
I believe our statute does that if they are willing to carry their burden of proof that it's not in the best interest of the child.
If you have to make a burden of proof to somebody, then you don't have the unilateral authority to terminate someone seeing your child if you think it's in their best interest. Right now, let's say that John was sitting next to you, and I don't want John to have any relationship with my son, no matter for whatever reason it is. I can say, John, you're not to see my son, and I can stop that. I don't have to go to any court, to any mediation to say that John can't see my son, even if John were the godparent of my child, and I wanted John to be in that role.
Then we have a philosophical difference.
I think we do.
If a adopting couple made an agreement voluntarily and voluntarily decided that they wanted it to be a reality, then they're choosing this process.
And the only thing I would say to you is that how voluntarily is it when you've seen the child, you've held the child, you're in love with the child? I would say to you there would be a tremendous amount of pressure on that adopted parent to probably sign not anything, but a lot of things so that they could take that baby home and love it. And that's
You
my
have another
concern.
question.
Sure.
You have another question. Representative Evans? Okay. Representative Welch?
Mr. Chairman, thank you. If it's appropriate, I'd like to make a motion.
Certainly.
Representative Fleming and I have
Thank you,
spoken
sir.
at length about the issue that he's raised, and I think he draws on the point of in voting in this bill, you are voting to allow parties to create a contract. And you're providing an enforceability mechanism for that. And the one thing that a unilateral break does not take into consideration is the effect on the child with whom there's been ongoing contact between the biological parent and the child. And so there's an effect not only on the biological parent, but there's also an effect on the child. So there's actually two parties that may be affected by that unilateral break. And that's where the tension has always been for me, is preserving the termination of parental rights and severing that so that the adoptive parents have full control. But as we've talked about this, there's a bundle of responsibilities that go with having children. And what we're doing is allowing this case for parties to contract and agree voluntarily, post-adoption, post-termination of parental rights, to enter into a contract. If someone is using that as a coercive manner to encourage adoption, people have to take personal responsibility and walk away from that adoption. So those are the issues, and with that, I'd like to go ahead and make a motion, recommendation of do pass.
Got a motion do pass and a second being abreast of the committee. I have I'm going to recognize Representative Coomer for purpose of posing a question.
Thank you, Mr. Chairman. I did have a couple questions, and I apologize because I wasn't in the previous committee hearing, and the questions raised by Representative Fleming actually kind of point to a couple other questions I had. Actually, I thought I understood the answers, but now I'm a little bit muddled about it. First one is there anywhere in this code, or I mean in this bill or in another code, where post-adoption contract agreements are defined?
Not that I'm aware of, no.
Because I'm not trying to be sarcastic with this comment, but I always understood a contract to require some consideration. And my question would be, what's the consideration to make this actually a contract? I mean, is this a situation where post-adoption the biological grandparent is going to come in and give some consideration to the adopting parents, and you pay them money for the right to have a relationship with the child? And if so, doesn't that offend public policy?
The consideration is the contact with the child with the biological parents, and this is post-adoption. And if the bill provides in line 78, a court shall not set aside a decree of adoption, rescind a surrender, or modify an order to terminate parental rights or any other prior court order because of the failure of an adoptive parent to a birth relative, or the child to comply with any or all the original terms of or subsequent modifications to a post-adoption contact agreement. So the consideration would be the child having contact. Okay.
I was reading the word contract where I should have been reading the word contact. That was part of my confusion.
Okay.
So that's fine. But I did want to clarify one other thing. In in lines 29 through 32 regarding jurisdiction, and this may be in other places in the bill as well, but it says that the court granting the adoption would retain jurisdiction over the post-adoption contact agreement.
Mm-hmm.
So that would, in some cases, be the juvenile courts would be sending that contact agreement back to the juvenile court for review in some cases, and to the Superior Court in other cases. Is that correct?
Correct.
Okay. Thank you very much. I'll try to read more carefully next time.
It's okay. I got confused several times with that same thing. Thank you. Okay. Any other questions? Any amendments?
Mr. Chairman, I have just a couple of amendments. On line 56, we use the word may file a motion, and as the chairman had pointed out to me just before our meeting, that really it should be a petition to force or terminate. So line 56, to strike the word motion, insert the line petition, the word petition. This would also be the same on line 62, strike the word motion, add the word petition. Line 63, strike the word motion and insert the word petition. That's my amendment.
I have a motion, a second. Although, any objections? All those in favor say aye.
Aye.
All those opposed, no. All right, it's as amended. So we'll be, are there any other amendments? Okay, Chair calls a question on LC 295549S as amended. All those in favor say aye. Aye. All opposed, no. Passes unanimously. Committee secretary. Yeah, with you got the amendments. Okay. Thank you. All right. Let's see. Where's my agenda go? Is he still here? Oh, I see. I want to recognize the distinguished jurist we have here today, Judge Bill Hamrick, formerly known as Senator Hamrick. Appreciate you being here. Glad you could. Would you mind standing, Judge Hamrick? Appreciate that.
I don't know if I'm a jurist yet, but
It's great to have experienced leadership in the judiciary and in our committee. Okay. Representative Fleming, you have House Bill 369. Where's it going to go?
Mr. Chairman, members of the committee, I appreciate y'all allowing me to come bring to you today House Bill 369. I have with me today Rebecca Crumrine. She is the incoming chair of the State Bar of Georgia's Family Law Section. And I will tell you that she's a much better lawyer than I am when it comes to the issue I'm about to address to you, so I will defer to her significantly. Let me tell you basically what the bill is about that's before you today. Unfortunately, forever in today's society, there are times when parental rights have to be terminated. And that usually happens for the juvenile court in the state of Georgia. But let's say that a divorce case was going on and it became apparent for whatever reason, usually in a fairly limited set of circumstances, that the Superior Court needed to terminate parental rights in the case that was involved in front of them. It would make not a lot of sense for the families involved and for the court system to have to go over and move that case to juvenile court so that parental rights could be terminated. And so this bill today corrects a situation that exists under current law, as recently pointed out by a Georgia Supreme Court case, and improves the law so that we don't have to have two cases going on, sometimes very volatile cases going on in two different courts at the same time, or having to stop a divorce case in the middle of it to go have a juvenile court make a ruling on the termination of parental rights. Let me just give you an example as a practical matter how this could arise. Two folks go before the court and they're getting a divorce, unfortunately. There's a child involved, and in the process of the divorce, it comes out that the purported father, the guy who's there in the divorce, is not really the father of the child. And for whatever reason, the court decides that it needs to terminate those parental rights, and because there is a biological father that's there. Now, a lot of different circumstances and stories you can put into that, but that does happen, unfortunately, occasionally. The bill you have before you today is intended to correct that situation so that that Superior Court judge who is hearing that case can make that decision and not have to stop the case and go file a whole totally separate case in the juvenile court. Now, Mr. Chairman, there are some other folks that have an amendment or two. I think Mary Margaret Oliver has one regarding some very specific situations that need to be considered. There was a discussion before we began the bill today to talk about some jurisdictional issues that may come out through testimony. I've had a chance to speak with Judge Hamrick, our judge of the day of Superior Court. Their current desire is to move ahead with the bill as is, but of course that will be your decision as you hear the testimony, I suspect, from different people. If I could there, Mr. Chairman, let me stop and turn this over to somebody who really knows what they're talking about, and that's the lady who is the incoming chair of the bar for the Family Law Section. I'll tell you that occasionally as a lawyer you get put in a situation where you're a Superior Court judge and you happen to be the only one from the Augusta Judicial Circuit in the legislature. Your Superior Court judge decides that you need to go correct a problem. And my good Judge Roper from Augusta is the one that told me I needed to come correct this problem. And with the help of some smart lawyers like the lady next to me, Mary Margaret Oliver and Regina Quick sitting up there on the committee, he told me to go be in charge and get this fixed. But I'm going to turn it over to the lady who really can answer any questions that the committee has at this time.
Thank you. Ms. Cromwell?
Thank you. Just for further explanation, and being also from Augusta, although we did not know each other, I was accosted on this as well. But I spoke to the Superior Court in their seminar, their judicial seminar in July, and it was the 2 days after Bryan versus Shipp came out, and happened to be doing the case law update and explaining to them, and they were up in arms about this because what resulted out of Bryan versus Shipp is that they said that the Superior Court doesn't have subject matter jurisdiction in a very limited situation that unfortunately is the result of at least 3 appellate cases from last year where there is an issue between a legal father and a biological father, and the Superior Court has to find in the best interest of the child whose competing interest there is, and because of the subject matter jurisdiction specifically that's provided to the juvenile court by statutory law that carves out from the Superior Court's exclusive jurisdiction that's constitutional, that there's no subject matter jurisdiction in those specific places. I understand some of the issues with regards to the bill from Ruth Claiborne and Jim Altman, who are here today, but I think I hope that I'm not speaking out of turn, that we are all on the same page in terms of what we want this to accomplish and what it is to accomplish. It's a matter of hammering out the language, and the Superior Court Counsel would like us to go ahead and move forward with it because I believe we're able to hammer that out and actually almost got it done before the committee met. But I'm here and happy to answer any questions at this point in time.
Okay. Just for my own edification, Ms. Crumrine, the problem we're correcting here will be the distinction when the Superior Court has before it an issue where a biological father and a legal father are in a dispute about who should have parental rights over the child.
Yes, sir. Exactly.
The Superior Court presently, because of statutory law which says that the juvenile court has exclusive jurisdiction over termination of parental rights, this would provide that the Superior Court would have the ability to terminate parental rights in one of the two based on what's in the best interest of the child.
Yes, in that narrow circumstance, and also continuing to have jurisdiction in adoptions to terminate parental rights as well. So those 2 areas.
I've seen this issue in my practice. I think I've got a good feel for what you're talking about. So thank you. Is there any questions from the committee? Wow, you're exactly right. She was great. That was good. Okay.
It's better to know the right people than to be right yourself, Mr. Chairman.
Amen. All right. Do I hear a motion?
Move do pass, Mr. Chairman.
Have a motion do pass and a second. Are there any amendments to the bill? Yes, ma'am. Representative Oliver.
I was brought into this a little bit late, so I'm going to state conceptually what I believe is an agreement among the experts within the sound of my voice. And then I'll offer an amendment, if I may, Mr. Chairman. And I offer an amendment on line 13 that the word concurrent shall be replaced with the word exclusive. And then I'll offer a second amendment.
Hold on, just to get this First Amendment. Where on line 13?
Yes, sir.
Am I on
We're
3?
replacing the word exclusive with the word concurrent.
That language is struck, is it not?
We're striking we're leaving the striking language in there. We're not striking the language. We're leaving it as it is. And we are replacing, so there's two parts of the amendment. We're leaving the language that's struck, unstruck. We're leaving it as it is. And then we're replacing the word concurrent with exclusive. I'm giving you this, Mr. Chairman, just for the purpose of discussion, so I believe so I'll be clear about, make sure I'm stating this correctly for the parties that have been working on this today. And secondly, at the end of line 26 on page 2, after the word child, it shall say, comma, except in cases of sperm donation pursuant to Official Code of Georgia 19-7-1 or transfer of legal rights to rights of embryos pursuant to 19-840 et sec. Mr. Chairman, we have had consistent case law on the legality relation to sperm donation and embryos that we don't want to undo in this bill. And I believe those are the two amendments for discussion purposes right now I've been asked to bring forward that I believe make this consistent with all the parties that touch this statute. And I'll ask Ms. Crumbine if I correctly stated the discussions that you had earlier today.
Yes, on line 26, I think it's 19.721, not 19.7.1. With regards to the changes in OCGA 15.11.28.
Okay, hold on just a second. I want to make sure that I'm clear and the committee is clear on the modification. On line 26, after the last word in line 26, which is the word child, insert comma, except in cases of sperm donation.
I can actually give you some better language that we've worked on while y'all are working on the other bill, if that's okay.
Well, let me just what's on the breast of the committee right now. There may be a modification to the, maybe amendment to the amendment. Sperm donation pursuant to OCGA section 19-7-1 or transfer of legal rights to an embryo or embryos pursuant to 19-8-40 et seq. Period. Or no, comma. And such termination in the best interest of the child. That's what you're saying.
I believe the code section, the first time you've read it, is incorrect. Would you please allow me to make sure I've got the right number from the earlier discussions? Yes. 19-7-21. Thank you.
Oh, okay.
19-7-21 is the first citation, Mr. Chairman.
Okay. Did we follow that on the committee? Let me just repeat that, just so we're all on the same page. On line 26 of LC 295492, after the last word on line 26, which is child, insert a comma. In cases of sperm donation pursuant to OCGA section 19-7-21 or transfer of legal rights to an embryo or embryos pursuant to OCGA section 19-8-40 et seq, comma.
That's correct, Mr. Chairman. I wanted to state those two amendments for the purpose of just confirming that that is what is satisfactory to parties that have been working on this, and to give those two amendments as example to the full committee for purposes of discussion.
Okay, Ms. Crumrine, hold on just a second. Representative Quick.
Mr. Chairman, I just wanted to speak to Section 1. I think Representative Oliver has outlined what is the consensus of the folks who've been discussing this with regard to an amendment of Section 2, but I do think we need to discuss Section 1 at the appropriate time and that proposed amendment. So I don't know if you want to treat those separately or not, but
We will. But since we're in the 2, we'll give it full time. I'll come back to you. Ms. Crumrine?
As to Section 2, we were in agreement.
Okay, so we're in agreement with Section 2. Let's take Section 2, the amendment to Section 2. Let's take it first. Does the author of the bill have any comment on the amendment to Section 2, line 26?
They know what they're talking about, Mr. Chairman.
Thank you. Okay. Any other questions or comment from the committee on the amendment to line 26 of Section 2? Go ahead.
Can someone just explain what this added language ultimately means to all of us? Because this is the first time we're reading it, and I don't have, and I don't think anyone here has, the code references for 19-7-21 and 19-8-40. I'd just like to hear what that's about.
Sure. Ruth Claiborne's here from the Georgia Council of Adoption Lawyers, and she can speak more.
You want to take the podium, please, ma'am? Ms. Claiborne.
Thank you, Mr. Chairman, members of the committee. In 1964, Georgia passed a sperm donation statute, and it says that when a child is conceived during a marriage as a result of artificial insemination, that the child is irrebuttably presumed to be the child of the husband and wife. The reason it's important in this particular code section is that we're about to say in this statute, which I assume that the purpose of this is that when there's been either paternity fraud or mistake regarding paternity, if you find out at the time of the divorce or other dispute that the man you thought was the daddy really isn't the daddy genetically, then if it's in the best interest of the child, they want to be able to relieve him of rights and responsibilities. And that's all fine and dandy unless this was a consented to artificial insemination performed by a physician, in accordance with written consent of the parties. So that's why I asked and appreciate the committee's consideration of taking of treating a sperm donor differently than a man who was mistakenly thought to be a father. In 2009, this General Assembly passed a bill called the Option of Embryo Adoption, and that is Code Section 19840 through, I believe, 43, and I worked on that bill quite a bit. The author of the bill did not want to call the people who gave the embryos to the other people donors because he had a philosophical issue with use of the word donor. And so Representative Jacobs and others came up with language that says that instead of you donating an embryo, what you do, according to our statute, is you enter into a transfer of legal rights to embryos in accordance with a written contract. And again, physicians are involved because that's a high-tech process. And so we're not interested in interfering with the fraud and mistake cases. What we would like to do is make sure that when people enter into a consensual arrangement and physicians are involved and so on and so forth, that might result in a non-genetic child, but it should still be considered a child of the two people who made it all happen. Does that make sense?
I think it does, yes, ma'am. And the amendment here does exactly what you're saying. It distinguishes between natural biological fathers and in the event of a sperm donation case. It doesn't allow the Superior Court to have jurisdiction. It would have to go to the juvenile court.
No, sir. It doesn't allow him to get off the hook. When you have a donor, when you have a child who is an offspring of donors, then he or she is still considered the legal, legitimate child of the marriage. So what we're not really trying to change it jurisdictionally. That these things do happen jurisdictionally where there's a dispute over these children in Superior and not juvenile court. So the purpose of the amendment is not to kick jurisdiction back to juvenile court. The purpose of the amendment is to say, wait a minute, just because this legal dad took a DNA test and he turns out not to be the genetic dad, if the reason he's not the genetic dad is because this was a donor child,
yes,
then he's still on the hook.
Right. Okay.
Okay?
Thank you, ma'am.
Thank you so much.
Any question? Just a second. Any questions from the committee? Thank you very much, Ms. Claiborne.
Mr. Chairman, if I may, I'll just second the amendment to Section 2 because
Okay. Let me pose a question. Ms. Claiborne, please, may need you to comment on this. Looking at OCGA section 19721, it provides that all children born within wedlock or within the usual period of gestation thereafter who have been conceived by means of artificial insemination are irrebuttably presumed legitimate if both spouses have consented in writing to the use and administration of artificial insemination. So with respect to the amendment, should we use artificial insemination instead of sperm donation?
That would be fine.
Okay. Okay. So is there going to be an amendment to the amendment?
It's
Mr. Vice
unusual.
Chair?
That's old-fashioned language. They don't really call it artificial insemination anymore, but it hasn't, the meaning is clear, and it does track the language in 19721.
Mr. Chairman, I propose an amendment to the amendment, striking the word sperm donation from the amendment and inserting the language artificial insemination in lieu thereof.
Do I have a second? Have a motion second. All those in favor of the amendment to the amendment, say aye. Aye. All opposed, no. Okay, so that would be that's actually amendment two as amended. Passed. Okay, now the amendment to section 1. I'm sorry.
The section 1 is to unstrike the language that is strucken and to insert.
Just a second, Ms. Oliver. I'm sorry. You probably are laughing at me because I didn't get we got the amendment amended, but we didn't get the amendment voted in. So, if we could, if you give me just a second. Now, on the amendment as amended, to line 26 of section of line 26. To have a motion. Well, we had a motion on that. All right, we got a motion. We'll call the question on amending the line 26 as amended. Amending line 26 by the amendment as amended. I have a motion there. And yes. Sure. Okay, and the amendment will read as follows as amended. Following the word child on line 26, which is the last word in line 26, comma, except in cases of artificial insemination pursuant to OCGA section 19-7-21 or transfer of legal rights to an embryo or embryos pursuant to OCGA section 19-8-40 et seq, comma. I have a motion, and do I have a second? I have a second. All those in favor of the amendment as amended, say aye.
Aye.
All opposed, no. Okay, thank you. Thank you, Ms. Oliver, for your patience. Would you go ahead with the other amendment?
The second amendment I wish to offer, Mr. Chairman, is in relation to lines 11 through 13, the language that is struck be unstruck, and that the word concurrent be replaced with the word exclusive. And I believe that does reflect an agreement for the folks that have been discussing this issue today.
It just goes through lines. If Ms. Oliver, just want to be clear about the what will be unstruck on, and looking at LC 295492, lines 11, where the language following the word child and comma, the language that's struck now reads as follows: other than that, in connection with adoption proceeding under Article 1 of Chapter 8 of Title 19, in which the superior courts have, it says concurrent now, you want to change that to exclusive jurisdiction to terminate the legal parent - child. That's your amendment, correct?
Yes, sir.
Okay. So it's just between here, it's just to right here. Okay. Is everybody clear about the amendment?
As part of that amendment, the other struck language is also unstruck, and I will make that as part of the first amendment. All of the struck language, both 11 through 13 and 14 and 15, shall be unstruck.
Okay. Now, we have a question. Mr. Spencer?
That was my question, was clarification, because she initially said 14 wasn't preserved. So
Thank you.
So we're just going to just do all of the, in lines, section 1, all of the lines that are struck now will be unstruck, and we'll change the word on line 13, which, as has been stricken, says concurrent. We'll change that to exclusive.
Yes, sir. That's my amendment.
Okay. Representative Coomer?
Thank you, Mr. Chairman. First, I'll point something out and then ask a question. This language at lines 10 through 15 is the same code section, same language that is addressed in House Bill 242, which is known as the Juvenile Code Rewrite, at lines, I believe it's 551 through 555, if I'm not mistaken. And my question is, does Section 2 of this bill fail in some way if Section 1 of this bill doesn't go forward? And the reason I ask that question is because if Section 1 of this bill is in conflict with House Bill 242, and let's presume for a moment the governor will sign House Bill 242, does that not create a situation where we may be essentially discouraging the governor from signing House Bill 369 because he doesn't want to create a conflict with House Bill 242 in that section? And it's a long way of saying, should we separate out Section 1 and consider it as a, let that be run as a separate bill if it's absolutely necessary?
Mr. Chairman, we discussed this issue about potential conflict with 242 earlier. I think I'm right, and I'm going to invite again people to correct me, that this Section 1 in the Juvenile Code relating to termination of parental rights is not in the Juvenile Code. It's in the Juvenile Code that relates to deprivation cases alone. So I don't believe there's a conflict, but that's the basis, and I ask people to tell me if there's, but I also, to the extent there might be a conflict, I don't have any objection to the necessary language that Legislative Council can offer us that say one part of this bill declared unconstitutional shall not.
If I could call Kirsten Widner from the Barton Clinic to respond to that.
Thank you. That's better.
Thank you, Mr. Chairman. With regard to how this language reads in HB 242, the jurisdictional language of 1511-28, which is amended in Section 1, was maintained in complete consistency in HB 242 in our agreement with the Superior Court judges, the Council of Superior Court Judges. So,
okay,
right
let me
now,
stop you real quick. So what it says in 242 is that they have concurrent jurisdiction.
yes,
okay.
the way the law currently reads in 1511-28 is how it reads in HB 242.
Okay.
My understanding is whether or not this amendment would be made to HB 242 depends on the order in which the bills are signed by the governor. So provided they're signed in the right order, this change would just be incorporated into HB 242 if this committee elects to act on it.
Okay, one other question. So if we wanted this to be included in 242, what's the right order?
I believe that that 242 has to be signed first.
Okay. Then this one would sign.
That's
be
right.
Signed, and then it would modify 242.
That's right.
Does that address your question?
It does.
Okay.
Thank you.
Okay. Thank you very much, ma'am. Representative Quick.
I just want to speak to what Representative Oliver has proposed, and this is sort of where we deviated and stopped our pre-meeting discussions, because leaving in the stricken language does not fix the problem for the Superior Court judges. That is exactly the language that was the problem in Bryan versus Shipp and then the subsequent cases, because the Georgia Constitution says Superior Courts have jurisdiction in all cases except as otherwise provided in the Constitution. It then goes on to talk about juvenile courts as a class of limited jurisdiction, having uniform jurisdiction as provided by law, and this code section is the law that the cases then cite to say that the Superior Court doesn't have any jurisdiction except in connection with adoptions, and that's all. And so you can't change 19.7.1 without also changing 15.11.28 and fix the problem, because 15.11.28 has constitutional significance in the way the case law has evolved. So you've got to strike it. And after we fully discuss it, I may have some additional suggested language, but you have to change it or you don't fix the problem.
Okay, so okay. Yes, ma'am. Ms. Crumrine.
Sorry. I think, and to add to what Representative Quick said, I think we are all in agreement as to what we want it to say. Nobody's trying to take adoptions away from the Superior Court. We're trying to add something. It's just a matter of how it's going to be written.
Mm-hmm. Okay.
And I think there is a thought that if we strike this language, that it takes the jurisdiction away from Superior Courts to be able to terminate an adoptions. And if I may add to what Representative Quick said, because the Constitution provides exclusive jurisdiction for Superior Courts on the language that's suggested at this point, as long as it says in accordance with Chapter 2 of this chapter, then what that does is that limits the juvenile court's termination to that only which is provided in the statute, and leaves for jurisdiction for the Superior Court as their exclusive jurisdiction, anything outside of that.
Okay.
Which would include adoption.
Representative Quick, does that address your concern there?
I think as long as the 15.11.28, I think Rebecca said it exactly correctly, that you've got to deal with expanding. It can't just, the Superior Court's jurisdiction to terminate parental rights can't be tied only to adoptions in this. So, for example, the language I think it should be is for the termination of the legal parent-child relationship and the rights of the biological father, who is not the legal father of the child, in proceedings conducted in accordance with Article 2 of this chapter. In other words, juvenile court should have jurisdiction to terminate in anything in Title 15 in the Juvenile Code, and Superior Court should have jurisdiction to terminate as spelled out in Title 19 and 19.7.1.
So we need another provision in 19.7.1 that gives them the sort of like what's in lines 10 through 15.
I think that's what paragraph 8 does, or at least is intended to do.
And paragraph 7 provides for the adoption.
Okay. Okay, now bring me back. I guess you're gonna have to bring me back to yours, Ms. Quick. To your comment regarding if we don't strike this language, then we still got a conflict.
And I'll let the Superior Court judges speak to it if they'd like, but I believe that if you limit it just to adoption and you do not take care of the problem that Brian identifies, you're right back where we were before we did anything.
Okay. All right. Okay. Mr. Altman, I see that you're signed up here to speak to the bill.
Yes, sir, I
The language that Representative Oliver put back in limits the carve-out to adoptions. If we said in connection with divorce proceedings under Chapter 5 of Title 19, in connection with the legitimation proceedings under Chapter 7 of Title 19, then left the adoption sentence there, and in connection with custody proceedings under...
Hold on just a second. You left me...
I'm sorry, too fast. If we look at the language on lines 11 through 14 that was in Representative Oliver's proposed amendment.
So, unstrike that.
Yeah, but add to it, what we have is we have the, if we think of the whole ball of wax of rights of, or jurisdiction for legitimation, termination of parental rights, it was originally in the Superior Court. The juvenile court was carved out of the Superior Court. This 1511-28 section we're looking at, C, handed it and said termination, original jurisdiction of termination of parental rights proceedings. If we want to carve out the exceptions for divorces exclusively to the Superior Court, legitimations can be in either court, and custody proceedings are only in Superior Court. So if we said, other than in connection with, I'm right on the comma after child on line 11, if we said in connection with divorce proceedings under Chapter 5 of Title 19, that would say they could terminate a parent-child relationship in a divorce. That was the Ship case. In connection with a legitimation proceeding under Chapter 7 of Title 19, that tracks the legitimation issue that I've have a legitimation action before me and I have a legal father out there. That's the Lebrecht case, series of cases in Davis v. Lebrecht, where the Supreme Court said we're very hesitant to delegitimate a child. Watch out when you do that. You're taking a child that has a legal status and now rendering him no longer legitimate. But if you can do it in the same stroke of the pen by the Superior Court judge in that legitimation proceeding of untie this knot and tie this one, then we don't have any gap there. Then we keep the phrase in connection with adoption proceedings under Article 1 of Chapter 8 of Title 19, and then add in connection with custody proceedings under Chapter 9 of Title 19. Then pick up in which case the Superior Courts shall have exclusive jurisdiction. That carves out of the piece that the juvenile court was given terminations in adoption, divorces, legitimations, and custody proceedings, which is, I think, addresses the Ship problem. And it keeps the structure the same that we've had for 30-some years. Doesn't monkey with that. I think it fixes it.
Okay. All right. You agree with that, Ms. Cromwell?
The issues I see in broad spectrum, yes, but the issues I see with it are, again, we have the Superior Court who has a constitution, the exclusive jurisdiction, and what you're doing now is you're limiting the Superior Court instead of limiting the statutory juvenile court's rights as it is in Article 2 of the chapter. I mean, it seems almost gratuitous in a way in limiting.
Okay. Tell you what I think we're going to do. We're going to try to work on this a little bit more. We'll have another hearing this week to see what we can do as far as getting this. We're just going to suspend at this point, and we're going to work this language out and get it squared away, make sure we're all on the same page. And I need to read a few cases, so just to make sure I'm on top of it. Okay. So we'll come back to HB 369. Next on the agenda is.
Thank you, Mr. Chairman.
Thank you.
Thank you.
Okay, we have Representative Peak with us today, and we have House Bill 446. Let's see. wherever you're comfortable, sir, up front would be best, if that's good with you. Okay. And we're using LC 335026, House Bill 446. Is that what you have, Mr. Peake?
335026.
Yes, sir. Thank you. Proceed.
Thank you, Mr. Chairman, members of the committee. Pleasure to be before this new committee, and glad to bring before you a measure I think that's it's well needed and something that will help deal with the guardian statute, adult guardianship statutes in our state. Kathy Simpson is here with me. She's with the Alzheimer's Association and is the driving force behind this bill. And so I'll kind of walk you through it real quick and then let her maybe give some comments, Mr. Chairman, and then answer some questions if that's okay. HB 446 amends the guardianship statute to it adds that during the guardianship petition adds a new requirement that there's an acknowledgement in the application that identifies any state in which the individual being guarded was physically present for 6 months prior to petition. Same thing in Section 2. It adds it except for during a conservatorship petition. Hard for a restaurant guy to say that. New requirement that there's acknowledgement in the application that identifies any state in which the individual being guarded was physically present, just to give notice that there's where a individual would have been 6 months prior to petition. And Section 3 allows the judge to have some discretion on the notice service in terms of the new allowance. Basically, this allows a requirement that a notice be given to other states in which an individual resided when trying to transfer guardianship one to another. It provides some protection against what some have called as granny snatching by improving the cross-state communication and notice. There's some overall Alzheimer's goals, and Kathy can tell them a little different, but this is part of the Alzheimer's Association that passed the Uniform Law Commission's recommendations for uniformity in guardianship statutes across the U.S., making a more streamlined process for getting guardianship across state lines. And this is particular importance for those with families who have Alzheimer's disease who reside in a different state. The probate judges have given positive feedback on this. Mark Middleton's here today if we want to chat about that as well, too. And if it's okay, Mr. Chairman Welch, I'll turn it over to Ms. Simpson and let her make and share a little more passionately about the need for this.
Thank you, Mr. Chairman and committee members and Representative Peake. We very much appreciate this language being brought forward. Our ultimate goal is to be in compliance with the Uniform Adult Protective Proceedings Jurisdiction Act. Georgia is one of only a handful of states that currently is not in full compliance. However, we recognize that the Georgia Adult Guardianship Statute is excellent. We just want to help tweak it to make it just a little bit better, and that tweaking has to do with the communication between courts of one state and another state to ensure that if my mother is currently residing with me and I have a sister in Tennessee that I take her to for a period of respite care, that the guardianship doesn't automatically pass simply because she lives in a different state. We want to ensure that there's communication between the courts on an issue called granny snatching. Our helpline, which is a 24/7 helpline, often hears of family members who are dealing with family dynamics, not caring so much about the care of the individual, but the resources that the individual has through the conservatorship as well as the guardianship. We just want to make sure that the people who have had previous guardianship or previous care of that person get notified that the new proposed guardian has filed a petition in the court of another state for that guardianship, so that there's a communication brought about, and then it helps to ease the family dynamics, and most importantly that it protects the individual ward for whom the guardianship is being sought.
All right.
Mr. Chairman, the basic bottom line is just make sure to have a notice requirement to make sure to protect our senior citizens, particularly those with Alzheimer's.
Thank you, Representative, and thank you, Ms. Simpson. Any questions for either Representative Peake or Ms. Simpson? Seeing none, we have another person that would like to speak on the bill, so just if we could, thank you very much. Does Mark Middleton, probate judge, would he like to speak on the bill?
I don't want to get in the way of the motion, Mr. Chairman. The probate judges appreciate what Representative Peake and the Alzheimer's Association are trying to do, and grateful for the opportunity to support it.
All right, with that, then we'll entertain a motion at this time.
Move to pass, Mr. Chairman. Second.
We have a motion and a second. The bill is in the rest of the committee. We'll take a vote on that. All those in favor of recommendation of due pass on HB 446, LC number 335026, say aye. Any opposed? All right, seeing none, it passes unanimously. Thank you, Representative.
Thank you, Mr. Chairman, members of the committee. Appreciate your support. Thank you very much.
Thank you, members of the committee. There's no other business before us at this time, so we will adjourn and try to see you back here maybe Thursday.